Hello, welcome to the September edition of Allsco Tax Chambers Tax Snacks. My name is Patrick Botch, and I am here with Ben Simons, my colleague. We will be discussing a couple of judgments that have been handed down over the summer. So perhaps you could tell us a bit about those, Ben.
Thanks, Patrick. Today we're going to discuss three cases. The first case is Judge Baldwin's decision in the Upper Tribunal case of Blaxendale-Walker and HMRC. This is an interesting case about the difficulties that HMRC has applying tax-geared penalties to a taxpayer for failing to comply with a Schedule 36 information notice request. The second case is the case of Mr. Denoit D'Angelin and HMRC. In that case, Mr. D'Angelin was a non-domiciled UK resident taxpayer, and he invested £1.5 million in a UK company and claimed business investment relief. He took a personal loan, a director's loan of £71,000, interest-free, and HMRC came along and audited this arrangement and claimed that that was an extraction of value. And, well, there was an argument as to whether he should be entitled to business investment relief. And, well, we'll discuss a bit more about what happened in that case later. And the third case is General Electric Financial Investments Limited and HMRC. That case concerned two stapled companies that were part of the General Electric Group. There was a UK and a US company, and they were both partners in a Delaware limited partnership. In brief, the matter at issue was whether the UK company was resident solely in the UK under the UK-US double tax treaty. If it was, it would be subject to double taxation on its income in both the UK and the US. And, well, that is a disastrous outcome for the taxpayer and not what the taxpayer wants, but we'll discuss what happened there later.
Sure. So if you begin sort of with a brief outline of the key issues in the Blaxendale-Walker case, what would you say about that?
Sure. The Blaxendale-Walker concerned a well-known promoter of tax schemes, Mr. Blaxendale-Walker, and it concerned HMRC's ability to levy tax-geared penalties on Mr. Blaxendale-Walker for failing to comply with a Schedule 36 information notice request. In that case, HMRC applied to the Upper Tribunal for a tax-geared penalty of over £14 million on Mr. Blaxendale-Walker for his failure to comply with a Schedule 36 information notice request. They made the application under paragraph 50 of Schedule 36, and Mr. Blaxendale-Walker sought to resist this application.
And what would you say is sort of the background of the Blaxendale-Walker case?
Yeah, Mr. Blaxendale-Walker's schemes typically involve using trusts engineered to pass benefits to beneficiaries in ways that supposedly avoided tax. Mr. Blaxendale-Walker is most well known for his Rangers Trust scheme, and HMRC successfully challenged that scheme. It went all the way to the Supreme Court, and, well, the scheme failed. It didn't work. And that was very like most of Mr. Blaxendale-Walker's other schemes. They just didn't work, and that's what the courts have found.
The dispute concerned the revenue's ability to impose penalties for failure to comply with Schedule 36. Can you say a bit more about that?
Yeah, that's right, Patrick. The factual background was very complex. HMRC was conducting many tax inquiries into Mr. Blaxendale-Walker's own affairs. And in this case, HMRC issued an information notice on 14 January 2022, seeking certain information from him. They extended that to 15 March 2022, and that notice was approved by the tribunal. Mr. Blaxendale-Walker sought a further extension of time of 14 days until 28 March 2022 to comply with that request. He failed to do so, and HMRC issued a fixed penalty of £300 on 29 March. Mr. Blaxendale-Walker appealed that penalty, and what was happening here was that Mr. Blaxendale-Walker was changing his address to evade service of HMRC's notices, and HMRC were getting frustrated with him. On 1 March 2023, HMRC withdrew their initial penalty and they issued a further information notice giving him 14 days to comply. They gave him until 15 March 2023 to comply with that information notice request. And well, they became very frustrated with Mr. Blaxendale-Walker. He was evading service. And on 15 March 2023, the very last day for compliance, they issued him with a fixed penalty of £300 for failure to comply, even though 15 March 2023 was the last day for compliance with that information notice request. And then on 28 March 2023, they made an application to the Upper Tribunal to issue Mr. Blaxendale-Walker with a tax-geared penalty for failing to comply of £14 million.
And how did Mr. Blaxendale-Walker resist HMRC's application for this quite substantial penalty?
HMRC sought to levy a tax-geared penalty under paragraph 50. Sorry, HMRC sought to levy a tax-geared penalty under paragraph 50 of Schedule 36 on the basis that, one, Mr. Blaxendale-Walker was liable for a failure to comply penalty under paragraph 39. That was the £300 fixed penalty. Two, there was a continuing failure to comply. Three, because of the failure, Mr. Blaxendale-Walker had paid significantly less tax than he otherwise should have. And four, HMRC has 12 months from the relevant date to make an application for a tax-geared penalty. In this case, the relevant date was 15 March 2022. That was the date of the notice that was initially issued by the tribunal. That is the relevant date, and that is very important. The initial notice that was approved by the tribunal was the date for compliance with that notice was 15 March 2022. And the tribunal essentially decided that on whatever view was taken of paragraph 50, HMRC had failed to comply with the requirements of paragraph 50. One view was that if the tribunal considered that HMRC had power to amend Schedule 36 notices, amend the date for compliance, they had no power to issue a paragraph 39 fixed penalty. That's because they issued that penalty on 15 March 2023, which was the last day for compliance with that notice. The notice had not expired. Time had not expired for Mr. Blaxendale-Walker to comply with that notice, and therefore HMRC, that penalty was not valid. They had no power to issue that penalty. Taking an alternate view, if one took an alternate view, and that alternate view being HMRC had power to extend time for a taxpayer to comply with notices, HMRC would have failed to comply with the fourth requirement in paragraph 50, which is that they have 12 months from the relevant date to issue a tax-geared penalty notice. The relevant date in this case was 15 March 2022, which was the time for compliance with the first information notice. And HMRC had until 15 March 2023 to issue a tax-geared penalty, but it was on 28 March 2023 when they made their application for a tax-geared penalty, so they were out of time.
Right. So this case illustrates, doesn't it, that it can be quite difficult for the revenue to comply with the requirements, and I suppose in some cases these sorts of penalties can be successfully challenged.
That's right, Patrick. If your client gets a tax-geared penalty from HMRC for failing to comply with an information notice request, it's worth checking whether HMRC has followed all the correct procedures to make that application. You may be able to save your client a lot of money if you do that.
Yeah. Thank you. That's excellent. So the next case we're going to discuss is Mr. Denoit D'Angelin, I think. Not sure. And this case concerned whether a UK resident, non-domiciled taxpayer, could claim business investment relief with respect to the foreign income of around 1.5 million that he had brought into the UK and invested in qualifying UK companies.
Yes, that's right, Patrick. Business investment relief was introduced in 2012, and it allowed non-dom UK resident taxpayers to bring foreign income into the UK and invest in qualifying companies. Those are really unlisted companies that are trading businesses. It's encouraging non-domiciled individuals to invest in the UK economy.
And what is the essence of the dispute?
In this case, the taxpayer was UK resident non-domiciled, and he made a director's loan from the UK company to himself on an interest-free basis, and it was about £71,000. HMRC audited this and said that this was an extraction of value, and therefore he didn't qualify for business investment relief.
And what did the revenue take issue with?
HMRC considered that the director's loan of £71,000 meant that the extraction of value rule was breached, and where this rule is breached, business investment relief is denied.
So because business investment relief was denied, the taxpayer was then subject to tax on the funds remitted, and I presume the entire funds remitted.
Correct.
Right?
Exactly, Patrick. So the taxpayer was subject to tax on the £1.5 million investment. It was tax of £675,000, and yeah, a very unfortunate outcome.
Yeah, and then he appealed. And what were the matters to be decided the appeal?
There were two issues. HMRC maintained that there had been an extraction of value because of the director's loan, and therefore business investment relief should be denied. The second issue was that Mr. D'Angelin claimed that even if there had been an extraction of value, he fell within a statutory exception. That is, he could make a loan to himself on an arm's length basis.
Right. And so in the first issue, the revenue maintained that the director's loan amounted to an extraction of value. Can you say a bit more about how the tribunal dealt with that issue?
Yeah, the tribunal considered that it was clear that the director's loan was an extraction of value. Mr. D'Angelin received, the loan was under his control and it was for his benefit. So there was no question that there was an extraction of value.
I see. And what about the second issue? Was Mr. D'Angelin able to defend the arrangement as falling within the exception on the basis that it was made in the ordinary course of business, the loan that is?
Yeah, the tribunal was happy to accept that a director's loan is an arrangement that is often made in the ordinary course of business. This was a small owner-managed company, and that is something you might see in a small owner-managed company. So that matter was easy to satisfy. However, the director's loan to Mr. D'Angelin had been made on an interest-free basis. HMRC disputed that it was arm's length. Mr. D'Angelin sought to argue that a third-party bank would have loaned him this money at low interest or no interest, but he didn't produce any evidence. And the tribunal therefore found that he failed to discharge his evidentiary burden on this point, and that he could not satisfy the tribunal that there had not been an extraction of value. He didn't forward an exception, and the tribunal considered there was an extraction of value.
I see. So a loss then for Mr. D'Angelin, unfortunately.
Yes, unfortunately, the case might have gone a different way if Mr. D'Angelin had produced more compelling evidence. If he'd been able to show that a third-party bank would have given him a loan at no interest, he may have prevailed, but he didn't do that. And the tribunal even said this possibility was not implausible, but because Mr. D'Angelin didn't do that, he lost. So, if he'd produced better evidence, the outcome may have been different.
Okay. So that concludes the second case then. The third case is GE Financial Investments. I think this might have been one of my cases actually, as of the revenue, just sort of by the by. But what's the background to this case?
Yeah, Patrick, this case concerned two companies that were partners in a Delaware limited partnership and were stapled together. As the name suggests, they were both General Electric companies. The UK company was General Electric Financial Investments Limited, and it had a 99% interest in the Delaware Limited Partnership. The US company was General Electric Financial Investments, Inc., and it was the general partner, and it had a 1% interest in the Delaware Limited Partnership. This is generally how limited partnerships work. The limited partner takes the majority share, they contribute most of the capital. They don't have any voting rights, or they don't do management, sorry, they don't do management. The general partner has a nominal investment, in this case 1%, and it does management. The Delaware Limited Partnership had 5 debts. They were the assets that it held, and it derived interest income from those. And it was the tax years from 31 December 2003 to 31 December 2008 that were in dispute. And for the purposes of domestic law, the UK taxpayer company, it was the UK taxpayer company that was the taxpayer in this dispute. purposes of UK domestic law, the UK taxpayer company was resident in both the US and the UK, and prima facie, the UK company was therefore subject to tax on its worldwide income in both the UK and the US.
And how did the dispute then arise in this case?
Yeah, the UK taxpayer company claimed double tax relief in the UK on its income in respect of US tax that it had paid on this income. HMRC opened an inquiry and sought to deny the UK taxpayer company double taxation relief. This resulted in the UK taxpayer company, General Electric Investments Limited, being subject to double taxation in the US and the UK. And not surprisingly, well, the UK taxpayer company appealed, and it appealed on two different bases.
So what was the first basis in which it appealed?
Yeah, the first base was that, the first base was that the taxpayer appealed on the basis it was resident in the US for the purposes of the UK-US double tax treaty. UK taxpayer company succeeded on that point. It would not be subject to double taxation on its on its interest income. HMRC maintained that the UK taxpayer company was resident in the UK only for the purposes of Article 4.1 of the UK-US double tax treaty. And if this was the case, the UK company would end up being subject to double tax on its interest income in both the UK and the US. It wouldn't have the ability to claim double tax relief in the UK. And this would effectively result in the UK taxpayer company being subject to tax in two different jurisdictions, and was an outcome the taxpayer was trying to avoid.
Yes, understandably. So Article 4.1 of the US-UK treaty, I'm just going to read out what it says. It says the term resident of a contracting state means, for the purposes of this convention, any person who, under the laws of that state, is liable to tax therein by reason of, and then get these criteria: his domicile, his residence, citizenship, place of management, place of incorporation, or any other criterion of a similar nature. So how did the Court of Appeal decide in relation to that provision, that the UK resident company was subject to tax for treaty law purposes?
Yeah, the Court of Appeal considered that the text of the treaty was the starting point for determining whether the UK company was resident, or where the UK company was resident for tax purposes under Article 4.1 of the UK-US double tax treaty. The Court of Appeal considered that the correct interpretation of Article 4.1 of the UK-US double tax treaty was that it laid out a number of factual and legal factors by which a taxpayer could be connected to a contracting state, and by reason of this connection, subject to tax on a worldwide basis. The Court of Appeal considered that none of these factors, in this case, incorporation or management and control, could suggest a connection to the US. They only suggested a connection to the UK. Further, the Court of Appeal considered that the fact that the UK company taxpayer was stable to a US company was not relevant for determining where the UK company was tax resident for the purposes of the UK-US double tax treaty. The Court of Appeal found that the UK taxpayer company was UK resident for the purposes of the UK-US double tax treaty.
And it had a second argument as well, you said. And what about that argument? What was that?
Yeah, the UK taxpayer argued that even if it was resident in the UK under Article 4.1 of the UK-US double tax treaty, it wasn't carrying on business through a US permanent establishment.
And how did the Court of Appeal decide that issue then?
Yeah, the Court of Appeal saw no reason to disturb the factual finding of the first-tier tribunal that the UK taxpayer company was carrying on business in the US.
So the UK taxpayer company was only holding debt investment, is that right?
That's right. And this isn't conducting a business. It was the fact that it was a limited partner made this challenging to claim it was conducting a business, but holding investments is not carrying on a business. It is just passively holding investments. And or the fact that it was a limited partner, partners don't undertake management of the partnership. They are just investors. So That is why that decision went that way.
Yeah, that sounds a bit like a bit of a tricky argument to make. So the taxpayer company, the UK taxpayer company, is subject to double taxation on its worldwide income in both the US and the UK. Is that the outcome?
That's correct. The UK taxpayer company was subject to double tax on its interest income in the UK and the US. HMRC didn't have to refund £124 million in UK tax.
Yeah, and it's all about paying the right amount of tax, we're told, but the taxpayer didn't prevail in this case. Do you have anything else to say about that? I mean, what do you think on the whole?
Yeah, I thought the Court of Appeal's reasoning was very rigorous, but the outcome was not one that accorded with the commercial nature of a stapled instrument, and it was an unfortunate result for the taxpayer.
Thank you very much.